Good afternoon, everyone. How are you? So the way we're setting this up today is that first I'm just going to go through sort of a general overview of who's eligible, a little bit about the court, who's eligible for orders of protection, what remedies are available in the order of protection, and so forth, as kind of a large overview of the statute. Then Danielle will follow me, and she's really the heart of the presentation because she is going to walk you through the form pleadings and the unique affidavit requirements that you will be doing as a volunteer in this pro bono project. So first, it seems a little, it might feel a little bit redundant, but for purposes of this presentation, we're outlining the law and then really making it clear what the practice is in terms of filling out the forms. I also wanted to say there are a number of different firms represented here today, and we have over 21 firms participating in this project today. So we're really glad to have you here, and we welcome you and hope that following the training, you'll complete the orientation and begin to do volunteer work on your firm's shift. So having said that, let's get started by, I wanted to just give you some idea of what the Domestic Violence Division is, as that's the division in which this practice occurs. And let you know that it is a relatively new division here in the Circuit Court of Cook County. It was created in 2010. And what it did is it combined both the criminal and civil order protection related matters within one division. What you need to know is previously, orders of protection have always been available in conjunction with a criminal charge. But previously that was heard at 13th and Michigan, and civil or independent orders of protection were at yet a different site. And so there was no presiding judge to preside over and supervise the logistics of the court. And so Judge Evans decided to combine them, and in 2010 created one division. Although we do exist in the suburbs, it's important for you to know that this project operates exclusively at the Domestic Violence Courthouse, which is at 555 West Harrison. It is an entire courthouse dedicated to nothing but domestic violence and stalking charges and cases. There are 10 different judges that operate at the Harrison Court, some of them hearing criminal cases, some of them hearing civil cases, but all of them, as part of a late duty, do hear these civil orders of protection. So you may be appearing in front of any one of 10 judges. Primarily the two full-time civil courtrooms that operate hearing independent orders of protection are the courtrooms in which you operate. On many days there is a third courtroom operating to hear these emergencies. So those are the courtrooms that you're going to be appearing in, seeking these independent orders of protection. We'll go through some of those administrative details later, but I just wanted to give you some sense of it. Prior to the passage of the Illinois Domestic Violence Act in the early 1980s, there was no such thing as an order of protection. Today you're going to hear about the broad range of remedies that are available there. But for purposes of the Pro Bono project, you should know that we have between 50 to 60 pro se petitioners that walk in the door of that courthouse every day, seeking emergency orders of protection. That's why this Pro Bono project is so essential, because as you will see as Danielle goes through the pleadings, if you were pro se in an emotional state, as many of these individuals are, and you had to complete these forms on your own, uneducated and unaware, you would see what a daunting task it is, and that's why this Pro Bono project is so important. In February of 2011, we launched the Pro Bono project, and I'm happy to say it continues today. It's quite successful, and none of the firms that began it have dropped out, and nearly every volunteer indicates that it has been a positive experience for them, both for the clients that receive representation as well as the lawyers who volunteer. So let me start out by the Illinois Domestic Violence Act really does, that is the law under which you're seeking the orders of protection. There are copies, booklets, that are distributed that have the entire statute in it that you can glance at and read through and have with you. But we just provide that today by way of reference. But if you were to look at it, you would see that there is a purpose section. Ordinarily, one doesn't start a training like this by going back to the very purpose, but in the case of the Domestic Violence Act, I think it sets the tone and illustrates what it is that we're trying to get across. And if you can understand the theory, then when the practice kind of seems unusual, you can reference back to the purpose and understand why. So generally, the purposes are twofold: achieving safety for victims and accountability for those who have perpetrated acts of domestic violence. Specifically, the Domestic Violence Act created the orders of protection as a method for getting to the purpose of safety for victims and also accountability for those who've used domestic violence. Orders of protection prohibit abuse and reduce the abuser's access to the victim and try to address related issues. As you can see, the actual purpose reads, support victims to avoid further abuse by promptly entering and diligently enforcing court orders which prohibit abuse, and when necessary, reduce the abuser's access to the victim, and addresses any related issues such as custody and economic support that really trap these victims often by fear of retaliation, loss of a child, financial dependence, or the loss of accessible housing or services from seeking the protection that they so desperately need. The Illinois Domestic Violence Act also recognizes that these victims who also find themselves as complaining or state's witnesses in criminal prosecution in a related criminal case nearly always require some supports that would not, to reduce the risk of further harm, that wouldn't necessarily be afforded through regular prosecution channels during the pendency of their case. So the orders of protection are permitted and are sought on behalf of victims of domestic violence cases within the division by the state's attorney's office. And when you hear a little bit about how it works, I only raise that because many victims that are coming to you as potential clients may have already been interviewed by the state's attorney's office that day based on a police report, and a determination will have been made that no criminal charges are going to be filed because the burden of proof is different, as you will learn. So with an order of protection, it's preponderance of the evidence. With a criminal charge, obviously, it's beyond reasonable doubt. So the state may feel they can't prove it, but that doesn't mean that they don't agree that there's a basis for an order of protection. So sometimes you'll be dealing with folks that have already been screened by the state's attorney's office, been rejected for criminal charges, and they're moving forward to seek a civil order. The other group are those who come seeking only the civil orders of protection. But it's important for you to know it by way of purpose that when we created the Domestic Violence Act, we recognized that people who are going to be prosecuting someone who has committed acts of domestic violence against them might need the protection of an order of protection, which includes many civil remedies. It's a little odd. So also recognizing that the risks associated with disclosure of abuse by the victim, actually disclosure of abuse to someone on the outside actually increases the risk for a lot of victims of domestic violence. This has been proven through research. And so the whole law was written with the idea that once that disclosure is made, you've got a heightened risk of further violence and potential lethality. And so we created remedies to address this stuff on an emergency basis and even in conjunction with a criminal charge. So the idea was that a few preliminary remarks. We're not going to get into the sociology of domestic violence too much, but we wanted to contextualize it a little bit and say that domestic violence is more than a violent incident. If you think about criminal prosecution, they're focused in on an incident, a crime that has been committed. Domestic violence for that victim is much more than that one incident. And what brought them in may be a host of things. And so as we review the applicable law, it's important that you really have an understanding of the dynamics and the context of domestic violence as you're interviewing your potential client. Because domestic violence is defined much more broadly than that one incident for which someone might actually face a criminal charge. So we kind of say the lived experience of the victims of domestic violence that are generally abused by intimate partners was really the template of why we created the specific remedies and the mechanisms for emergency relief that you're about to hear about today. So just in terms of context. When we actually sat down to craft what the specific remedies were, we looked at the experience of victims and we tried to craft remedies that matched it with the goal of safety for the victim and accountability for the person who's perpetrating the violence. So the best recitation of that without going into a 3-hour lecture is really something in the front of your manual, which is called the power and control wheel. I would ask you, we're not going to go through it, but I would ask you before you come over to volunteer that you sort of familiarize yourself with the content of it. Because what it is intended to illustrate is the concept that I just was talking about. That what a lot of victims have experienced is the dynamic of what's represented on that chart. So if you think of the wheel itself as the violence, the sexual abuse, and the harassment, then all those spokes and those subparts of the pie are really, that wheel comes together, and that dynamic rolls around in that person's life, taking form and shape in many of the ways that are illustrated in that power and control wheel. So at the point that you're seeing them, they may be talking about harassing and threatening phone calls, not about a battery that had happened 2 years ago that made that threatening phone call content meaningful. So If you were a prosecutor, you'd want to be prosecuting that battery. You might not be so thrilled about that threatening phone call if you didn't understand the backdrop of the battery that had happened 2 years ago. Too long ago, potentially, to have filed a criminal charge, but recent enough, taken in its context, to be represented in an affidavit, thus making someone eligible for many of the remedies within the order of protection. So I ask you to just get a sense of that, and if you do, you'll understand as we're explaining the remedies, that remedies were created to address many of those slices of that pie. Also, as you hear us talking about ex parte and emergency relief, you'll understand it better. Because what we're trying to do is wedge ourselves into that cycle with an interruption that really could only be done if it was done on an emergency ex parte basis. If you recognize that the research says the risk increases at point of disclosure, if we went through the regular notification of filing and so forth that would be required, it would actually potentially increase the risk. So we created a lot of this based on ex parte and emergency relief. The last thing I wanted to say to you before we move on to the specific content of the law is that there's one more page in there early on that's, I think it's called danger assessment. Again, I would ask you to look at that as well. That is a tool that is really derived from extensive research that has been done. It's evidence-based research that says that taken in combination, many of those things that are attributed in that list represent heightened risk. So when you're interviewing someone, if you're running into trouble, sometimes that list can come in handy to make you think about sort of a checklist of things, although there's a wonderful interviewing tool in the main manual that also facilitates that. But if you just have a sense of it, the wheel and the risk assessment, danger assessment piece really illustrates that coercion, intimidation, economic abuse, threats in the use of children, the whole idea that victims will minimize and feel blamed for the domestic violence, and the isolating behaviors that often accompany the abuse are all illustrated. That's what we're trying to get across in those two handouts. So please take a look at them. So moving forward to the basics of the Illinois Domestic Violence Act. The orders of protection are really, as I said now several times, a tool for achieving safety. But the order of protection alone may not fully address a victim's safety need, and that raises the concern, that raises the need for a conversation related to risks and making linkages to other ancillary services, and there are a number of ways to do that at the courthouse. There are people in the courthouse that will help you do it. I think that Danielle is going to talk about this. There are advocates, and there are obviously Danielle as a resource for you that can help you link people that might have needs that aren't specifically addressed by the legal remedies that you have available. So we are able to link people up to more social support, housing, things like that, if that becomes important. The Act itself also says that it's about prohibiting current abuse and trying to prevent future abuse. So when you're interviewing people, you're hearing about the current abuse, but you're also thinking about prohibiting other kinds of abuse that might be likely. And the Act itself recognizes a very large range of relationships, which I'm going to get into on the next slide, and recognizes that there are many acts of domestic violence which are crimes, and then there are others which constitute abuse as defined under the Domestic Violence Act, making someone eligible for an order of protection. Ensuring that that pattern and history of abuse is reflected in the pleadings is what Danielle is going to stress to you as she goes through it, but it bears stating now, too, that that's the main impetus that we're trying to get across, that a person who receives pro bono assistance gains that a pro se litigant doesn't, because they don't often know to represent the pattern and the history in the way that you are going to be guided in doing. It also provides for ex parte emergency relief, which I've already said is intended to address the risk of violence. And there are some remedies that are limited in the emergency order, but we'll get into that in a second. As I said, there is a range of relationships and a wide scope of forms of abuse experience that come into that domestic violence court. Some family and household members covered under the Illinois Domestic Violence Act do not reflect the dynamic that I'm talking about. So if you get a case where you might be representing a brother who is being abused by another brother, obviously some of that power and control stuff doesn't apply, but some of it does. But in the intimate partner cases, which are really the cases we try to get to more often, it is so. As I said, victims in our courthouse can petition for an order of protection in both the criminal and civil cases. You're going to be assisting those who are seeking the independent civil OPs. And just for your interest, sometimes an OP can start in our domestic violence division and ultimately be transferred out to juvenile court or to the domestic relations court. We try very hard not to give those cases to pro bono attorneys because you don't want to follow them out. Your letter of engagement, your retainer is going to limit your representation to only that order of protection, only at the domestic violence division. So we try not to get those, but just in terms of instruction, it's interesting to note that we can grant an emergency order of protection for somebody who's got a divorce pending, and then it gets transferred and consolidated. Or someone that you've worked on an order of protection, they subsequently file for a divorce, and that will be noted in the divorce proceeding, although not formally transferred. As I said, we do have all sorts of attorneys on site that work for the organization Danielle works for. Danielle's available as guide, but even with these attorneys on site and these domestic violence advocates that work for programs, nonprofits that are not lawyers, but they kind of assist people, even with all of that in place, we still have a lot of people that had no assistance at all. So that's why this is so important. As I said, people who are walking in with police reports, you'll note when you're there, are being pushed back to talk to the state's attorney's office when they have a police report. The state really wants to talk to them because they believe that if a police officer at scene found probable cause to complete a police report, even if an arrest wasn't made, perhaps the abuser was off scene and they weren't pursuing, but they wrote a police report, the state's attorney wants to talk to them to see if there's a basis for a charge before they just push them forward to civil. But most of the cases that come in and are screened by the state's attorney's office ultimately come right back out to us, and at a little bit later in the day, seeking a civil order of protection, which is why we need you there so desperately. Everything that we're going to teach you this morning or this afternoon about orders of protection, whether it's in the civil court or a criminal court, the order of protection is the same. It's a civil matter no matter which courtroom it comes into. So someone might come in that you're interviewing and say, I had an order of protection a long time ago when I had criminal charges, but I didn't follow through, the charges were dropped, so I lost my order. That will make sense to you. The order, you might ask them what was in your order because you may just want to replicate what was in the order or what needed to be changed. So we just want to provide that background so that you're not thrown when you hear that sort of stuff coming out of people's mouths. The pleadings and the orders are forms. They're long, they're redundant, they're kind of convoluted, but that's why Danielle is here to walk you through them, and we're going to be covering all the provisions right now. So the first thing that I wanted you to know is there are three kinds of orders of protection: emergency, interim, and plenary. We hardly ever get interims, so we're going to focus our conversation today on emergency and plenary orders. So let's get into it with the emergency orders of protection, which is where your representation will begin. As I've said now a couple times, emergency orders of protection are granted ex parte, and we've already sort of explained why that is. The risk increases, so the judges are permitted to actually entertain these filings and hear them same day on an emergency ex parte basis. Because of that, in order to make it constitutional, we had to limit remedies and we had to limit duration. So the way it became constitutional was that the remedies are limited, which I'm going to go into, and the reasons, as you think about this, is because there's been no service, the kinds of remedies that are not permitted under an emergency would, by common sense to lawyers, make sense because you wouldn't want to affect permanent custody and things of that nature without having the respondent in the courtroom to really have their opportunity to be heard. But a lot of the remedies that are about safety and interruption of ongoing abuse are available on the emergency basis, so if you think of it that way, it'll make sense. The other thing is the order on the emergency basis only lasts for 21 days. Actually, it can be between 14 and 21 days, and lately we've had a couple of judges who've been granting them for 14 days instead of the full 21. So don't be thrown if that happens, but generally that is the point. When they get their emergency order of protection, they obviously come back within 21 days, the date, of course, being set at the hearing, And often when they come back the first time, there hasn't been service on the respondent, and an extension is made on the emergency order, and you're back again once they get service. I think that's it. So on the plenary order protection, here's how they vary. It is a final order, and because it is a final order, you must have had service on the respondent. Because you've got service now, the judge can order the plenary or final order protection, longer duration order protection, for a period of up to 2 years. So now it becomes a significant period of time. It can, not that this is something you're going to be dealing with, but it's interesting that if it's over the domestic relations division and it becomes part of the final divorce decree, it can actually be incorporated and go on forever. Sometimes that's done. And also on the criminal side, just in case you experience this, you could have a client who had an emergency order of protection granted. Upon conviction, the abuser was sentenced to a period of time in jail, and they will let the order of protection start date for running clock start running when the release is when the defendant is released from jail, or the offender is released from jail. So the 2 years start to begin at that point. Many victims come in to the Harrison Courthouse to get an emergency order of protection, and they do not follow through for plenary orders for lots of reasons. Sometimes the 21 days was enough of a window of protection for that victim to feel that they got their needs taken care of, and they might have filed some other kinds of actions over in the domestic relations court, or they just decided that that was enough of an interruption. It was a wake-up call to the abuser or respondent. But for lots of reasons, they don't, or they just can't make it in, or occasionally they're coerced into not following through. Any number of things can happen, but the reason why we place it here in our presentation is to make sure that you know that often, even when all you do is get the emergency order of protection, you have really helped that victim. And you shouldn't feel badly if your client doesn't follow through on the plenary. Although I have to tell you, we are getting much, much greater rate of follow through to plenary order when people have an attorney. I guess it makes a certain amount of sense. They feel supported, but that's just sort of the proof of the project in my mind, that we've got victims who actually stay with it, follow through, and get the full relief that they need. It's a success in my head. And it indicates victim satisfaction. This is the main slide that you really do need to pay attention to. It's kind of a cheat sheet, although you have many really good cheat sheets that Danielle has developed for you in your manual. But for purposes of this discussion, this is really the crux of it. And that is sort of who can petition for an order of protection. It is the first line here, a person who has been a victim of abuse at the hands of a family or household member. So when you're interviewing someone, although we do some pre-screening, so it's not that difficult, most of them do fit by the time you're interviewing them. But just so you know, that you basically got two things you have to establish here. You have to make sure that they've suffered some form of abuse that makes them eligible, and that the abuse had to be perpetrated by someone who stands in a family or household relationship to that victim. So abuse, again, I'm reflecting you back to the power and control wheel, but this act says it includes these things. All of the abuse definition includes physical abuse, pretty obvious, but it's even pushing, shoving, slapping, and then of course the more obvious battery, punching, kicking, strangling, choking, and the list goes on. Those are pretty evident. But the things that are less evident are things like harassment. And harassment in the statute, if you have a chance, you might look at it, but by way of presentation, there are some specific examples laid out in the statute that includes things like repeatedly calling, following, threats of force, confinement, or restraint. All constitute, by way of definition, harassment for the judge. We try to help the judge in making decisions about what constitutes harassment by guiding them with some specific examples. Now, when the law was written, that was before stalking was sort of a known thing. But back then, there wasn't really a term for it, and so we just used these examples of harassment. There's also intimidation of a dependent, and you can read that's about subjecting another who is dependent to participate or witness abuse of another. There's interference with personal liberty, which is really about compelling someone to conduct or refrain from conducting some activity against their will. and willful deprivation, which is about depriving a dependent of necessities which expose them to risk of harm. What's important here is to pause and say that you don't have to have had physical abuse. You can be eligible for an order of protection based on activities that would fit the definition of harassment only. So there could be all kinds of emotional abuse, there can also be sexual abuse, those kinds of things, and there may never have been a fist or a pump or a punch or a shove of any kind. That doesn't exclude them from seeking an order of protection. So in its totality, you can see that this stuff fits together, and you're going to be able to get a history that might reflect an incident that brought them in that was harassing, but a history of a physical abuse incident that might have happened 5-6 years ago. But that's the goal of your interview, and Danielle will show you how that is done on the pleadings. So you've met the criteria of abuse, and then you move to family or household definition, household member. Family is these subparts. Persons who have or had a dating relationship. Dating relationship is not defined. There's been a little bit of case law on it, but generally speaking, it has to have been like more than one contact. But a lot of young people don't date anymore, so I'm hanging out. So you really that's a little tricky part of your interview, but if you can characterize it as dating, generally they will be found eligible. Obviously spouses, but also ex-spouses. Lots of people presume that people who are married where there was abuse, then they get divorced, that the abuse stops. Well, no, it doesn't. Lots of ex-spouses come in and as the abuse is continued post-decree. People who have or allegedly have a child together or a child in common. Danielle's going to talk to you a little bit about how you speak to somebody about paternity, but the important thing here is that they don't have to have established paternity. They have to allege that the child that they have together makes them eligible to seek an order of protection. There's lots of places where minor child is defined as the children in common, and we'll talk about the protections that are afforded to kids. These others are parents and adult children. That's pretty evident. Siblings, step relationships are eligible. People who are related by blood or marriage, and people who share or allegedly share a blood relationship through a child. The related by blood or marriage are like my sister-in-law. I could get an order of protection against my sister-in-law because we're related by marriage, things of that sort. The persons who share or allegedly share a blood relationship through a child, we sometimes actually do like, that's called Venn diagrams, literally, to figure out people's relationships. It sounds very straightforward, but sometimes you're sitting, you're thinking, now wait, you're related to this person, how? So if there's a direct blood connection through a child, but there was no marriage. So if I needed an order of protection against the mother of the father of my child, does that make sense? So this would be my mother-in-law had we been married. I can get it because we're related through that child, blood, direct blood, okay? But not my husband's new wife, okay? So, there are some little tricky things there. That's what Danielle's there for, but most of the time that's all going to be determined when you get it. Last of all, there are these categories of third-party petitioners, and very quickly, you don't get many of those, but any person on behalf of an abused person who because of age, health, or disability cannot file, a third-party person can come in if the abused person, because of age, primarily age, can't come in. This, by way of example, happens most often when a parent comes in to petition on behalf of a minor victim against an adult boyfriend. So my daughter is 16, she's dating a 21-year-old, and the 21-year-old is abusive. Generally speaking, it's one of her parents or a friend that's an adult that can come in and petition on that young person's behalf because of age they are unable to. Does that make sense? Anything you wish to add, Danielle?
Just skipped over household members.
Oh, I'm sorry. Yes, I did, didn't I? Trying to keep this moving. And too fast. Household members, thanks, Danielle, include obviously people who live together or have lived together in the past, regardless of the nature of their relationship. So they could be roommates. They could be past roommates. If they shared a dwelling, they're eligible for orders of protection against one another if the abuse has occurred. They can be roommates and be intimate partners. So sometimes you've got a gay or lesbian or transgender victim sitting in front of you that doesn't necessarily want that to be noted as a dating relationship in their pleadings. Many don't care. some care, and if that's true, they may come in under household member, as just one example. And then there is caretakers for disabled victims. Generally speaking, you don't get those. But by way of interest, it's because caregivers are so often practically members of the household. They're in and out of the household in an unfettered way, so they were made eligible. Okay. Now, did I miss anything else in there? Okay. So, as I've said now several times, there are fewer remedies on the emergency order because it's ex parte. But there are a couple things about why this is an emergency that we want to get across. First of all, some of our judges are unfortunately sometimes asked questions about physical manifestations. What you need to know as a lawyer is there's no need for any kind of physical manifestation. They don't have to have called the police. They don't have to have gone to a medical facility. None of that is required, even though judges sometimes ask. So you have to step up and say that, that's not required in the statute. But what is required is to prove that the harm that you're seeking to prevent would likely occur if notice were given. That's kind of a standard. Danielle's going to repeat it again and again when we get to the pleadings. But if you recognize that it's really about preventing further harm, that we're trying to interrupt that risk, that's what you're trying to get across. Now, sometimes you'll see a little note on the bottom that people will wait. They'll suffer an incident and then they'll wait. Or people who have been in these relationships for a long time can almost sense that something is going to escalate. Like a threatening call comes and they know from in the past experience that that's a precursor to something, and they'll try. They'll worry about it for a little while and then they'll come in. Okay, so the point is that sometimes there's a delay. If there has been a delay and it's been more than a week, even less really at this point I would say, you have to illustrate or try to get to why that is. Danielle gives you some very good questions to use in an interviewing guide that do not feel blaming or, like an interrogation. But we really do need to get the facts from the person you're interviewing about why it was that they delayed, because we still have judges who think that if there's been any kind of delay, it works against the argument that they should need emergency relief. If you were in such danger, you would have come in immediately. So we're trying to work against that possibility in presenting our cases. Who can be protected? Now, this is a little different than who's eligible. So, as again, when Danielle goes through the pleading, she'll show you this. But people think that just by the caption, you would assume that that meant the victim, the petitioner, was going to be covered. No, they need to be listed on a spot that Danielle's going to show you. But so obviously the victim, him or herself, is a protected party. But what's really interesting is moving beyond who is eligible to petition and include some people that might be reflected on that person's order. And that would include, most obviously, the children of that victim, sometimes other family or household members that might need protection, and sometimes people employed by the victim in their home, like a babysitter. So the important thing here is, as you hear Danielle talk, you're going to hear where we place children's names and whether they are children in common or not. If they're children who need protected, sometimes you can list them in a line that lists the parties who are eligible to be protected. The reason why this is important is you're going to hear me talk about enforcement. So they could do something that was an act of abuse or making some kind of contact with any of these protected parties, and the enforcement is the same. It doesn't necessarily have to be some kind of contact with the petitioner, him or herself. So that's why it's important to name everybody that you want to have protected. Okay, moving to the emergency order protection remedies. Obviously, this is just going to be a checklist. You're going to see them again on the forms. But it's important for you to know that these remedies, again, are designed to protect the victim and often her children. Once she's shown she's a victim of domestic violence, she can ask the court for a significant array of these orders before the abuser's aware, again, that she was even in court and what the allegations were that she made to get these remedies. So, again, the IDBA is specific about what has to be shown to get several of these remedies, and it appears on the forms themselves, and Danielle will run through that, but it does kind of guide the court about what facts they must be considering and what findings they must make in the statute, and some of them are under specific remedies. The tests are under specific remedies. So we have, obviously, the prohibition of abuse, and that can be the full definition of abuse. So we're not only trying to mark prohibited abuse for things that have happened in the past, but also prohibiting abuse about things that we want to prevent from happening in the future. Under exclusive possession of the residence, this is a particularly infamous part of the law. On an ex parte basis, the victim can seek to have the respondent actually removed from a shared residence or granted exclusive possession of their own residence where he may have no right to be present. So these are very, very important things. One would think that it would be very difficult and constitutionally challenging to exclude someone from their very residence on an ex parte basis. So in order to do that, you have to do this thing that's called balancing the hardships. And it's really about who is going to be harmed more once you establish that they have some right to this, which is reflected in the forms themselves. You're really balancing the hardships by saying who's going to be harmed more. The abuser who has to get out of the shared residence or the victim who has to live in fear of abuse or risk of further abuse if she or he were to stay in the home. And the law kind of presumes that the balance will be in favor of the victim. Generally speaking, we don't have a lot of difficulty getting exclusive possession of the home in many instances on these emergency orders of protection. In the beginning, it was more difficult. Now, the sort of jump to why can we do this on an emergency order is kind of understood by the court. There is also a prohibition about entering the residence under the influence. This is about a victim who does not necessarily want to have the abuser excluded from the home altogether, just doesn't want that individual in the home while they're under the influence. So it's not a total get out, it's a you can't be here while drunk or high. So, and I know Danielle's going to focus on that when she gets into the pleadings, but you don't want to get exclusive possession and don't be in the residence while drunk on the same order. It's you're out, or you're allowed in, but not allowed in while drunk or high. And this will be reiterated again by Danielle, but that's the distinction, yes.
Could I ask a quick question?
Sure.
And this may seem obvious. Who enforces this? Would someone go and take the perpetrator out of the home before
Yes.
she has to go back, or does she have to call when she gets there?
She calls, once he's served, if he's there when the sheriff arrives to serve him, the sheriff will make him leave.
Okay.
Okay. If she wants to go home before she's served, then there's an instruction in your packet about you notify the police. The police will sometimes accompany.
Yeah, absolutely.
There's some specific instruction, and I'm sure Danielle will go through that again. Okay, but some victims go home and stay there until the sheriff actually comes and puts them out. You know, they just sort of remain quiet. It's not the best instruction. Danielle's giving the eyeball. But sometimes that's an alternative. So she's going to instruct you on that.
No, I could see that.
It's curious.
Yeah.
So, but those are the questions about the home, the shared residence. And it's not always a shared residence. She may just want to have exclusive possession of her home, telling him or her that they can't come near that place. The other thing is the stay away provisions. And stay away really comes in one of two ways. There's sort of the generalized stay away order, which says stay away. Stay away no matter where the petitioner is. So if that petitioner has that order and they're in a public place where both parties have every right to be, once this order is in place and it's been served and he or she is aware that they're subject to this order, if they were to walk into a McDonald's, for example, and see that individual, see the victim sitting there, they know they must leave. There's no question about it. So anywhere she is, they have to stay away from. There's an alternative about staying away from specific addresses. So somebody might get an exclusive possession of their home remedy, and then they might just say, I don't want this individual to come near me at my work, at my children's school, at my church or synagogue or mosque, at my favorite bar. Really, it gets down to that. So they can name some specific addresses if they don't feel that they need the entire stay away order. So these are things you're sort of pulling out during your interview. If the victim has children, remember we're going to name them as protected parties up in one section, and we're also going to work on awarding physical care and possession of the child to the victim. So this is not custody. This is just saying on the emergency ex parte basis, what you're going to do is you're going to say these children are going to be physically in the possession of the petitioner. That just tries to cut down on the conflicts about where these kids are going to be. It helps law enforcement when they go to serve to know where the children are supposed to be, and so forth and so on. So physical care and possession of children is a remedy that is available on an emergency order of protection. You really have to find that the children would be in need of protection from abuse, neglect, or separation from their primary caretaker in order to get that remedy. But that's a pretty easy burden to meet in many instances. So we also can prohibit removal or concealment of children, and also order the respondent to appear in court with the child if, let's say, the petitioner had fled the home and left her children behind, and now she can't get her kids. There's a whole array of different ways this can happen, but all those remedies are there, and Danielle will be talking about them as she goes through them a little bit on the petition, so I won't belabor it. And you can also protect property and or have property returned to you, and so forth. And I know Danielle's going to cover that when she gets to that section of the remedy. But these are properties like cars and contents of a home and things of that nature. You can prohibit the respondent from having access to children's records. Sometimes the petitioner will have left the home that they shared, taking her children with her, relocated, pulled her kids out of school, re-enrolled them. The respondent's trying to find them, and they go to the school records to try to track them. It's school records, it's medical records, it's anything like that, and you can prohibit access to them. And then there's other injunctive relief, which Danielle will cover in a little bit. It's used sparingly, except when some people sometimes want to have some degree of contact under the order. I wanted to say that one threat of abduction is not necessarily going to enable somebody to get a lot of this relief, but child abduction is something that is often at play, and so we've got to be careful about instances where someone might actually have threatened to take the child out of the country or out of the state, and be attentive to asking for those remedies that might address that. Now, when you're completing the petition, it's important for you to know that the form petition that you're going to be preparing on the day that you're volunteering for the emergency hearing is actually the petition that will play forward or carry through to the plenary. So there's only one petition being filed. It's what you're going to be relying on to make your emergency ex parte hearing, but it's also the very petition that's going to carry you through to your plenary. So your interview that same day is also about the relief that they may need in the plenary order, while distinguishing for them that that's not something they're getting that day, right? So these are the remedies that, again, are going to be reflected on your original petition if that victim wants them, but are not going to be heard on the emergency. That's temporary custody. Now, it's important for you to know that on the emergency, they can get physical care and possession. On the plenary, they can actually try to get temporary custody. And really, the standards there are very different than those that would be that they would be required to meet over in a divorce action. All I'm going to say to you about that right now is that it's really child custody related to safety, both the safety of the child and the safety of the custodial parent from the respondent. If you need to have temporary custody awarded in order to ensure safety, then you need to be asking for it on your petition. Similar argument can be made around child support, and then moving away from children, there are things like compensation for expenses that arise out of the abuse, so medical bills, lost work, things of that nature, sometimes with proof. Damage to cars is one. They can be ordered to surrender weapons. If that's the case, then you're going to want to, if there's a gun involved, you're definitely going to want to talk to Danielle, because there's a lot of extra steps that need to happen there. So, but it's important for you to know that if that does come up, it is possible to have the weapons confiscated under the order of protection. And last of all, a judge can order the respondent to get counseling in a plenary order of protection. Now, why is this all important? It's important for the reasons that you were pointing out: enforcement. And a violation of the order of protection, once it's issued and once he's been served, certain remedy violations do constitute a misdemeanor criminal charge called a violation of the order of protection. Around the courthouse, it's called a VOOP. Now, VOOPs can be charged whether the order originated from criminal court or like one that you had gotten civil court. If there's a violation, doesn't matter, now it becomes a criminal matter. The violations are if there's another act of abuse, and it would not have had to have been an abuse incident that would have constituted a battery. It could be just a threat. It could be just that he came over to the house when he or she was not supposed to be there under the order of protection, even if the petitioner wasn't present. It's that violation of the abuse, exclusive possession, and stay away that were the respondent to do that after notice, they can be arrested and charged with a boot. That brings that over into criminal. That's very different than lots of restraining orders and other kinds of relief that we used to try to get for victims of domestic violence before this law. This is why people get it, so that it has some teeth in enforcement. The police are required to take a report or make an arrest. And just as an aside to you, for the Chicago Police Department, a violation of order of protection is supposed to be a mandatory arrest situation when the abuser is still at scene. They don't have to pursue, but if they arrive and a VOOP has occurred, there's no discretion, they're supposed to be making an arrest. The reason is because they're violating a court order, it's not the victim's decision. By the way, a victim cannot violate her own order of protection or his own order of protection. They can invite the respondent over, and if the respondent comes, they're in violation, they can be arrested. So of course we don't want our clients to be engaging in that sort of stuff. It cuts against their credibility at point of plenary hearing, or even when they try to prove beyond a reasonable doubt the charge. Should he be charged? So we work with victims so that they understand that if they do in fact want to change something about their order of protection after it's been granted, there is a way to do that. It can be modified, it can even be vacated if they really don't want it anymore, and it's better if they do that than just start inviting over or just start reconciling and doing things like that, because later they may need it again and their credibility is less strong were they to have behaved in that way. Happens all the time for complicated reasons in people's lives, but it's an important part of advice that you can offer. Again, the respondent has to have been served, obviously, to have that kind of violation prosecuted, but if the police are on scene and he hasn't been served, they can notify him, and then if he doesn't leave or he continues his abusive behavior, then he's been served. So with that, I'm going to turn it over to Danielle. Can you see him? I can't see that. There's no monitor on here. Just switch it. Go down to the tray on the very bottom. That's you, right? Yeah. Now just go slideshow. Up at the top. No, go here. Go at the very top.
Right, file.
No.
Or view.
Here.
Sorry, do you want to do it?
Yes.
Sorry. Technical.
Sorry, we thought we knew what we were doing. Wow.
Sorry for the technical difficulties. First, I'd like to just take a second and introduce myself. My name is Danielle Parisi-Raffato, and I'm an attorney with the Domestic Violence Legal Clinic. Here's my contact information in case you need to reach me. To explain a little bit about who I am and what I do, I work for DVLC, and we are a private legal aid clinic, and we're located in the Domestic Violence Courthouse at 555 West Terracing. We partner with the court in this pro bono project. So I work very closely with Leslie, and I also staff the project. That means that when you come for your volunteerships, and while your cases are ongoing, if you have any questions, concerns, feel free to call, email me, or stop by, and I hopefully will be able to help you address your concerns. I also just wanted to explain that DVLC also does order of protection cases and other family law cases. So we're in the building doing some of the same work that you will be doing as part of this project. However, the need is so great that one legal aid clinic with a small staff absolutely cannot fill it. We are not going to address a lot of the specifics about what happens when you come to volunteer. And that is because we will have an orientation session. You will be asked to come and do an on-site orientation. There is one every month. We have one on November 26th from 9:30 to 11:30, and then we will schedule another one probably in early December. During that orientation, what will happen is you'll come to the courthouse, we'll take a tour, I'll run through what happens on a shift, let you know about some of the other resources that are available in the building, and sort of how cases get to you, so you know what has been covered already. And then we'll go up and observe some court proceedings, and we'll give you an opportunity to see some of the courtrooms and see what happens, and then also to ask questions if you have any about why something may or may not have happened in a particular case. There's also an outline of the volunteer shift on pages 4 to 5, so feel free to take a look before you come for orientation. And then this is a shift-based project. You will be asked to come to the courthouse for a 9 to 1 or 11 to 3 shift on behalf of your firm, where during the shift you will interview a potential client and hopefully accept their case, prepare their paperwork, and take them up to court that same day. You will then continue to represent them for the duration of their case. So you will proceed to potentially a contested plenary hearing. I'd like to talk about filing for an order of protection. And this gives you an overview of the documents you need to prepare in order to file for an order. We're going to focus the most on the petition for order of protection and affidavit. The petition for order of protection is a form pleading, and so there will be a lot of boxes that you will be checking and blanks you will be filling in. The good news is that the forms do most of the work for you. The bad news is they look very confusing and daunting at first glance. The affidavit is where you will lay out the details of your client's relationship with the respondent and what has happened. The summons, sheriff's information sheet are for purposes of service of process. They're pretty self-explanatory, as well as the domestic relations cover sheet. It's a form that the court requires. And finally, you will be drafting an emergency order of protection for the court because they're time-consuming to prepare. You're going to draft one. The judge may or may not enter it. The judge may make modifications before he or she signs the emergency order. All right. So first, we are going to address the affidavit. And the affidavit really is the heart of your case because it lets you explain why your client feels that he or she needs the protection of the court. It is attached to the petition, and it explains the client's relationship with the respondent, the incidents of abuse, both specific and the general overall pattern of abuse, the need for an order of protection, and why this case is an emergency. There's just a little note. Generally, we're working with situations and facts that our clients know, but an affidavit is generally for situations where someone has personal knowledge of what's been going on. However, there will be exceptions to that. There will be situations where your client will say, my mom told me the respondent stopped by my house looking for me, or he called my coworker and she told me that he was saying bad things about me. That's fine to include in the affidavit. You just need to designate that those things are on information or belief. And if necessary, if you do go to a contested hearing, you will want to see if that individual or those individuals can come in and testify about those additional incidents of abuse. All right. I'm going to ask you to turn in your manual to the sample affidavit, and there are actually 2 versions on page 35 and 37. You can look at either one. I suggest though reading through both before your first volunteer date. And first, I just want to address why there are 2 versions. The first version shows an array of different types of abuse, and it gives a great examples of how you would potentially address physical abuse and harassment, things that happen on information or belief. However, not all cases that walk into the domestic violence courthouse are this severe. Many of the clients that you will be working with will not have actually experienced physical abuse at all, or they will have experienced, it's hard for me to say that any form of abuse is minor, but not particularly severe incidents of physical abuse, but they can see that the situation is escalating, or maybe there's been name calling and there's been harassment in the past, but now there has been a slap or a push or a broken cell phone or something that makes them feel that the situation is more severe. So the second example gives you a less severe fact pattern that also absolutely is an appropriate case for an order of protection. Did you have a question?
I did, sorry, that's all I asked this question.
What are the elements of domestic violence?
Is physical contact required?
No. That is a good question. Physical abuse is absolutely not required under the Domestic Violence Act. And if you go back and look through the PowerPoint handout, one of the slides that Leslie handed out gave different types of abuse. Harassment is sufficient, physical abuse is sufficient, intimidation of a dependent. There are a number of different types of abuse. Most cases that you deal with will include emotional abuse of some sort, and then potentially also some sort of physical abuse. So I want you to glance at the affidavit so you can see how it's structured. And I also want you to try to hold one of those pages and turn to page 9, because I just would like to address the interview questions for a moment. Interview questions begin on page 9, and they are intended as a tool that you can use to gather the information you need to complete the affidavit and the petition. Now, you won't need to ask all of the questions. For example, the questions in italics are only relevant if the two parties have or allegedly have children in common. They're completely irrelevant for all other circumstances. However, the intent of this is to really cover all situations that we can think of, and to start with questions you need answered for the purposes of the affidavit. And so the interview questions start out by asking about the relationship, how long the parties live together, if they have children in common, and then going on to the incidents of abuse. And there are follow-up questions: what happened next? What happened after that? How did it end? How did this incident end? Were the police called? Was a report filed? And this is all information that will be relevant for the purposes of your affidavit. The interview questions continue, and they finish with the affidavit, and then they go on to additional questions you will need to complete the petition. So all of it is really laid out for you in these interview questions. I would like you to turn back to either page 35 or 37, and we will see how some of those preliminary questions play into the affidavit. And that is, in that the first paragraph identifies the nature of the relationship, whether the parties have any children in common, if they ever lived together and when they separated. All questions which are laid out in the beginning portion of the interview questions tool. The second part of the affidavit is where we go through the incidents of abuse. And we need to plead specific facts. So it's very important to go through time, date, location, who was present, and then make specific allegations as to what has occurred. So what specifically happened? If the respondent hit the petitioner, how did he or she hit the petitioner? Was it with an open hand or a closed fist? How many times was the petitioner struck? If the petitioner was grabbed, where was she grabbed? If a cell phone was broken, what exactly happened that led to the cell phone being broken? Was it stepped on, thrown across the room? Was it stolen? Details such as this are very important. And that is the number one mistake that a pro se petitioner will make when filling out this paperwork and when going up to court and presenting their case in front of the judge. Because the judge will ask what happened, and the petitioner will give conclusions. They will say, he harassed me, he abused me, he beat me up. Those all are things that may have happened, but those are all conclusions. The judge needs to hear the specific facts that led the petitioner to conclude that they were abused, harassed, or beat up. We usually present in reverse chronological order to address the emergency nature of the case. As Leslie pointed out, the judges will want to know why, if there has not been a very recent incident, potentially in the past week or so, why that person has delayed coming to court. So we set out the emergency nature, put the most recent incident or series of incidents first, and then if there is any delay, we also explain why that has occurred. And the samples include, again, incidents of physical abuse, harassment, and also include a summary of the abuse. And the summary paragraph, which is the one of the last paragraphs in both samples of the affidavit, is important because, as Leslie mentioned, abuse often follows a pattern, and there are, first of all, often there's a long history of abuse, and your clients may not remember so much about specific incidents that occurred months or years ago, but also because there are non-criminal actions and controlling behavior that also contribute to your client's status as a domestic violence victim. They're all part of the abuse, and they're all in that power and control wheel. And where the fact that a respondent has called the petitioner names may not be enough for the court to give them an emergency order of protection, that is an important part of the abuse when you take into account that there may have been physical abuse, or there's been harassment and stalking, and then there's also been this name calling, or also cutting the petitioner off from their family or friends, prohibiting them from leaving the home, things like that. So there's a space, you're really going to create space in your affidavit to include all of that. All right, paragraph 2 allows, the IDVA allows the court to prohibit specific acts of abuse, the things that have been already happened, and also things that otherwise appear likely to occur if not prohibited. So in the first Smith v. Smith sample, everything has occurred. But I just want you to know that you can modify this, and you should modify it to fit your needs. So if there has not been physical abuse, but your client is concerned that the abuse will escalate to include physical abuse, you can put, I'm fearful that the respondent will stalk me or will physically abuse me, for example. Also, just remember not to follow these verbatim when, for example, you have a client who does not have children. The sample will say, I'm fearful for me and my children, or I'm fearful for the safety of my family. That may or may not apply in your particular situation. Just make sure to change it so the affidavit fits. All right. And finally, paragraph 3, as Leslie mentioned previously, the IDVA states that an emergency order of protection shall issue if the harm that the petitioner sought to prevent would be likely to occur if the respondent were given notice or any more notice. So the statement made in paragraph 3 is necessary to establish the need statutorily for an emergency order of protection to be granted. I also want to point out that there is a portion of the interview questions which addresses this exact portion of the statute. That asks if the petitioner is fearful of the respondent, if the petitioner feels that the respondent would try to stop them or hurt them, if they knew that the petitioner was seeking this order of protection. Okay. Now I'm going to turn to the petition. And again, these are form pleadings, which is sort of a mixed bag. If you check the right boxes, the form is making all your legal arguments for you, but it's important that you check the boxes and follow through. You'll also see that there are boxes and sub-boxes and sub-sub-boxes. You really need to follow the logic through and make sure that you are kind of completing the thought. If there's a balance of hardships, you need to check why the balance of hardships favors your client, for example. Another thing to note is please don't skip the numbered or lettered boxes. The fact that you have filled something in on the line does not necessarily make it clear to the respondent or to the court that you are requesting that remedy. All right, I'm going to ask you to take a look at the sample petition which is in your materials, and it is on page 30. And the first thing we're going to do is to just look through a sample petition and just look at the structure. Now this is a sample, so this is a fake case. It's an example of how a petition may look in a certain circumstance. But I really just want to address how the petition is structured. First, the first about page and a half really establishes basic information about the parties. It gives the petitioner and respondent's names and addresses. It establishes venue and jurisdiction over the parties and minor children. Then you move on to a section where you make allegations as to specific remedies. You basically state that the petitioner has been abused and that this remedy is a good idea. And then in the third section, you actually request those remedies. Now the letters in the second section of the petition and numbers in the third section of the petition literally match up so that when you ask for exclusive possession of a shared or not shared residence, that's the second allegation you make. It's also the second, it's also number 2 on the list of remedies, and it all just very much goes together. So just to demonstrate that, if you could really quickly look at page 2 of the petition, which is like page 31 of your materials, and if you look about 2/3 of the way down the page, you will see a section that says petitioner alleges as to respondent that. And again, this is the part where the petitioner starts to make allegations. The first thing, paragraph I, under that section, is a list of the protected persons, the people who need protection from abuse. If you look ahead to page 33, which is page 4 of the petition in the middle, you will see remedies requested. And then the first thing under the remedies requested section is the list of people who need protection. If you flip back to paragraph J, which is where, if you were pro se, you would be stuck trying to detail the incidents of abuse. We just write in, see attached affidavit, and that these incidents have caused fear and stress, and cover all of this in our client's affidavit. But if you turn then to the page 4 again, where the remedies requested section is located, and look under paragraph 1, paragraph 1 is where we prohibit specific types of abuse. And just to illustrate this a little further, paragraph K, which is on the top of page 3 of the petition, that's page 32. That is where you ask for exclusive possession of a shared residence or a residence that only the petitioner has a right to be in. And then the corresponding section under remedies requested is number 2. And it follows through in that way. So you will be absolutely repeating yourself. You're not hallucinating. But the purpose is to make the allegations and then specifically ask the court to grant those remedies.
Can I ask a question?
Yeah, sure.
On the first page of the petition where we're putting petitioner's address, let's say they just left the shared home, but now they're going to be staying with their mother.
Yeah.
Do you put the mother's address or do you put the petitioner's legal residence?
That's a good question. So first, one of the sort of a related issue that I want to address because it ties into your client's safety is that there is a spot where you can put, there's a way in an order of protection case to keep that petitioner's address confidential. So if your client is going to a location and they don't want the respondent to know where they're going, you can put care of your firm's address. And what that does is let any court documents come to you, but conceals the petitioner's address. So my first question to any petitioner in that circumstance would be, does he know where that is? So that may be one thing. Whether you put the address where the petitioner is going or the home, really, I think depends on where the petitioner plans to be. In our office, we usually put the residential address that the petitioner plans to occupy. on the petition. So what I would say is if your client wants to go back to the residence and wants to ask for exclusive possession and has the potential to get that, I would put that address on and then we'll kind of follow it through. If your client wants to go to a different location, you can either put that address or put address amendment. Okay?
Another question.
Yeah.
What do you put for respondent's address if you don't know what his address is?
Yes. If you do not know the respondent's address, usually in our office we'll put the last known address or the address we're going to try to serve the respondent at. Okay? And actually, to address more questions like that, we are going to turn to a guide that will hopefully help guide you through the petition. And the guide is located on page 14. So if you could please turn there. And I wanted you to take a look at a completed sample petition, just so you could get an idea of the structure of the petition. But this is really where we're going to address those nuts and bolts of what you put where. And I just wanted to also explain again and just refer again to the interview questions. You don't have to look there now, but please know that on page 11, where the interview questions are located, the petition information begins, and all of the questions you will need to fill out the petition are contained in the interview questions guide. So, as we already talked about, the first about page and a half of the petition asks for basic information about the parties. If you look at page 14 in your handout, you will see a screenshot of the very top of the petition followed by some information about what to write where. Generally, you will have one petitioner and one respondent, and you're going to check the box for independent proceeding. There are some rare situations where you may have an on behalf of situation where somebody is seeking an order on behalf of typically their minor child. You would need to follow the instructions, the second paragraph instructions about on behalf of. In the next section, we're also always going to write the petitioner's name on the line after the word petitioner. And then if it is an on behalf of situation, you would put the person who the order sought on behalf of on one of the two lines following. Then, if you look at page 15, we are going to list the petitioner's address. Sorry. As we just spoke about, you may want to list the petitioner's address, or you may want to keep that address confidential. And there are instructions about how to do both of those. Please note that there are 3 options for checkboxes under paragraph A. If the respondent knows where the petitioner resides, check the first box. If the petitioner's address should be confidential, check the third box. Then under B is the respondent's address. So list it if it's known, if it's unknown. We typically use the last known residential address. The only situation where I would not do that is if we know the respondent works or stays with us, or we think he stays with a family member, I would put that address, the address we're going to try to have him served. But if nothing else, always put the last known residential address. Regarding the relationship of the parties, we're going to check the appropriate boxes, and Leslie went through what those different relationships are. And then at the bottom of page 15, which is the top of page 2 of the actual petition, we're really always going to check the first box that there are no pending actions between the parties. We would not give you a case where there is an ongoing case, such as a parentage or divorce case. And that's something we'll talk about in more detail when you come for orientation, but we will be screening those cases out. On paragraph E, you are going to list the minor children, and we are going to address what that means. The minor children as a term of art, and it comes to mean children the parties have in common. Whether paternity has been established or not. So any children that the parties have or allegedly have in common go on line E. The individual's other children, so children that your client may have from a prior relationship, do not go on this line. They can be protected by an order, but they're not identified as minor children because none of the issues that we will address related to minor children are going to need to be addressed in those circumstances. Okay. You check the boxes as appropriate related to jurisdiction. Typically, 1A applies. The children live in the state of Illinois and have always lived in the state of Illinois. There is a note in the interview questions that if you ask the client and it comes up that the children have lived in another state, to come grab me. There are some other ways that Illinois can assert jurisdiction over the kids, but typically Illinois is the home state because the kids were born here and have always lived here. We also are going to talk a little bit about establishing a father-child relationship, and if you look at paragraph F, there's a line for children as to whom a father-child relationship has not been established. I want you to know that there are some resources at the end of the packet that address issues such as this and child support and exclusive possession of a residence in a little bit more detail. But for the purposes of today's training, I would like you to know that there are a few ways to establish that a man is the father of a child. If the two parties are married when the child is born or conceived, it's presumed. There are no other steps that anyone else that the father needs to take. They're presumed to be the legal father of the child. If two parties are not married when a child is born, the father needs to take some steps to assert that he is legally the father, to be legally seen as the father of that child. Most often, that is through something called a voluntary acknowledgement of paternity, which we call a VAP for short. And again, there's more information about this on page 47. If a VAP is signed, and only if a VAP is signed, can the father's name go on the birth certificate. So you either pretty much are married, and then it's presumed that the husband is the legal father, or if you're not married, you usually sign a VAP, and that puts the father's name on the child's birth certificate. There are other ways, and that typically happens very early on in the process. Hospitals are equipped with these forms, and so literally a lot of clients sign these shortly after giving birth, and that allows the father to claim basically rights and responsibilities such as visitation, potentially asking for custody and child support. I will let you know that there are other ways, for example, judicial means to establish legal paternity, but most of the cases you will be dealing with, it will come down to whether a VAP has been signed and therefore the children's names have been, the father's names have been placed on the birth certificate as to those children. So how does this play out in the paperwork? I mentioned that paragraph E is where you put the minor children, meaning all of the children that the parties have in common, whether paternity has been established or not. Paragraph F is where you list the children as to whom that father has not established legal paternity. So you make that distinction. E is all of the kids the parties have in common. F is those that the parties allegedly have in common as to whom the father has not established legal paternity. And then it makes it clear for the judge, everyone else listed under paragraph E, we're assuming that that father has established legal paternity. I'm sorry, I know that's a lot of information. Does anyone have questions just about that section, about how to establish legal paternity or how to reflect that on the forms? Yes?
So a child who's from a different marriage or previous marriage but is living in the home, do they go on? No.
Thank you. The question is, a child who is from a different relationship but is living in the home. A child, in that situation, that child can be listed as a protected party just like any other household members. But the protected party line is the only place we put those kids.
Okay, even if it's like an adopted child and literally the father is the kind of legal custodian of the child?
Well, that's a different situation. You said even if it's an adopted child.
Well, yeah, I mean, I guess what's the distinction? You know, when you're talking about, you know, the minor children, is it?
Minor children are children that the parties either have or allegedly have in common. So it would be situations where a child is born and both parties know that the boyfriend or ex-boyfriend is the father of that child, whether legally there's been a mechanism to establish paternity or not.
Right.
If you're dealing with a child that's been formally adopted by those parties, then it would be a legal child. The father's legal paternity will have been established.
Okay.
That make sense? Yeah. An adopted child, if you've formally been through that process, then legally both parents are the custodians of that child.
Okay. This is what I want to make sure.
Yeah. Okay.
So to be clear, if the father's name is on the birth certificate, you could assume that he signed it after and he's the legal father.
Yes, with the exception of some children who were born after August of 1996. So if you get somebody who is 17 and a half, there's the slight potential that that may not be the case. For practical purposes, it's going to be the case.
Okay.
All right, and if you have any questions about whether legal paternity has been established or not in a particular case, that's part of why I'm there. We're going to give you basic training today on what generally we can expect to happen, but there are always exceptions in really unusual situations. So please feel free to ask me if it comes up. Going back to the petition, we also list somebody as the primary caretaker under paragraph G. And again, this is only if there are minor children listed under paragraph E. We typically our clients, the petitioners, are the primary caretaker. Sometimes it's both of the parties equally, whoever the name is of the primary caretaker. And then we deal with venue, and in most cases, the three top boxes are the ones that are appropriate. That the petitioner resides in Cook County, the respondent resides in Cook County, and that the alleged abuse occurred in Cook County. Check whichever ones apply, and then note that there is a box at the bottom, box number 4, which lets the court, makes Cook County the appropriate venue if a petitioner has fled abuse and come to Cook County. Again, that comes up rarely. If it does and you have questions, please feel free to ask me. Okay. And then we go on and start making allegations of abuse. So again, this is the part of the petition where we make allegations and we're going to repeat ourselves when we get to the remedy section. The first box I, is where we list people who need protection from abuse. And as Leslie pointed out, it's not assumed that your client is covered by this order. So you do need to list the petitioner's name. And you can also include other household members, such as children in common, children who are absolutely not in common, so your client's children from another relationship, your client's mother, your client's sister, other people as long as they share the same household or are a child of your client. I think I already covered this, but just keep in line with what we've been doing. Under paragraph J, under incidents, you don't need to summarize the incidents of abuse. You can just write, see attached affidavit and the effects. We typically write fear and stress. And the affidavit will literally be placed in between pages 2 and 3 of the petition. So it's all really one document. And then we're going to go on to the allegation basically that petitioner needs exclusive possession of the residence. We typically ask for exclusive possession of a residence in almost all cases that our office deals with. And that is because the court can give you exclusive possession of a residence as long as the petitioner has a right to be there. If the petitioner has a right to occupy that residence and the respondent has no right to occupancy, then it's very straightforward. The court doesn't have to do anything else because the petitioner has a right to be there. If the petitioner has a right to be there and the respondent also has a legal right, for example, if there are two parties who are married or a household where both parties are on the lease, Then the court has to go through the balancing of the hardships and basically establish who would be harmed more by being excluded from the residence. The reason that we ask for exclusive possession, even if the respondent has no right to be there, is number one, because we can on the order, and to some degree that's what the judges are used to doing. But number two, it's a very strong protection for that residence, because then the respondent can't go to, come there, stay there at any time, regardless of whether the petitioner is there or not. Also, just practically, these orders go into LEADS, which is a law enforcement data system, and that's how they're enforced. Police officers, sheriffs, other law enforcement officers have access to that database, and they can see the remedies that are checked off. 2 is one of the first ones that comes up. Whereas if the client is protecting their home in addition to 4 other addresses, it might get sort of lost in the shuffle. So we just want to be clear that if the petitioner does not want the respondent to come to their home, we check, hey, we exclude them from the residence, whether we ask the court to balance the hardships or we're just asserting that petitioner is the only one who has a right to be there. On page 17 at the very bottom, I put rarely leave blank. And as Leslie mentioned, there are some situations, and they don't come up that often, but where a petitioner only wants to prohibit the respondent from coming to their home while they're under the influence of drugs or alcohol. There is a prohibition, there is a box we can check pretty much later on in the petition, but we want to do our best to make sure that these orders are clear and that they don't contradict each other. So obviously you don't want an order that says on one hand, you can't come here at all, but also you can come here, but only while you're not under the influence of drugs or alcohol, right? Those two things conflict. So we want to make these orders make sense. The stay away provision, which is paragraph L. There are 2 boxes under paragraph L. The first one says that the respondent should be ordered to stay away from petitioner and protected persons. Stay away under the statute means no contact by any means, including through third parties. And while the petition does not lay this out as clearly as it could, the order, when we get to the order, states the petitioner, the respondent can have no contact, no phone calls, no emails, faxes, letters, in-person electronic communication, any sort with the petitioner or any other protected person, so anyone else who's put on that protected person's line. The second box under L is different, and you're not going to necessarily check both of these. It does depend on the circumstances. The second box under L is where we prohibit the respondent from coming to other addresses while the petitioner is present. And it can be the petitioner's workplace, school, the petitioner's children's school, daycare, occasionally other addresses of family members or friends, particularly if those individuals have been also harassed by the respondent, or if an incident of abuse has occurred there. And then again, there are boxes underneath where you can either assert that the respondent has no right to be there. The respondent doesn't work there, that's the petitioner's mom's house, and the petitioner's child from another relationship's daycare. The respondent has no right to be in any of those places. Or that there's a balance of the hardships. So maybe the parties have a child in common and you're prohibiting him from coming to the children's school. But based on the circumstances, we're saying that the balance of hardships favors your client. And finally, counseling. Under paragraph M, the petitioner can request that the respondent be ordered to attend counseling. This, again, is one of the remedies that is not available on an emergency order. However, you are creating these pleadings for the whole case. So it's important to include everything on the petition, including things that the court does not have the power to grant at the emergency stage. Okay, issues related to minor children. So these paragraphs N through R only apply to children that the parties have or allegedly have in common. And again, children from another relationship are treated like other family members, and that is because the respondent has no rights, and there is no question that the respondent does not have any rights to have visitation or to be ordered to pay child support or to have custody of children that are not his, either through birth or adoption. Whereas if the respondent has asserted paternity of his children, yes, he has those rights. And if the parties have children in common or allegedly in common where legal paternity has not been established, we still want to check some boxes on the petition to ensure the safety of those children, taking into account that whether or not a respondent has actually signed a VAC and is actually on the birth certificate, the dad might be known as the dad by the daycare. The dad might be known as the school, might be listed as an emergency contact. So we want to take some sort of preemptive steps to ensure the safety of those children. So because of that, paragraph N, O, P, and Q on the petition, you're going to check regardless of whether paternity has been established or not. If paternity has not been established, we usually check Q because we want to make sure that there's not an incident of child snatching. And R is rarely used, and that is because if there has been an incident of child snatching, there's another mechanism that we use in Cook County to have that child returned before the next court date. And that is addressed in the back of your manuals. Okay. We're going to move on to personal property. And there are two paragraphs, S and T, which deal with property of either the petitioner or that the petitioner and respondent share. Paragraph S is for property that the respondent has that the petitioner needs back. So those are things like a cell phone or an ID that was stolen or even a car that was taken. Paragraph T we use all the time, and it is for situations where property needs to be protected from damage, abuse, or theft. So we routinely put the interior and exterior of the residence. We put the petitioner's car on here. We may put other property that's still in the respondent's home, like clothing or pictures. But, and there are some, this doesn't happen usually, but there are some situations where we would check both S and T and put the same property under those. But typically, we're either asking for the property back because the respondent has it, or the petitioner has it, and we want to keep things that way. And so we are checking box T. And finally, there is the possibility to protect pets that either the petitioner owns or the parties own jointly. So they'll give the petitioner exclusive possession of those pets and also protect those pets from harm. This does come up on a fairly regular basis. Part of domestic violence sometimes includes harm or threats of harm to animals that are important to the petitioner or important to the petitioner's children. And that can occasionally be something that keeps the petitioner from leaving a respondent, is fear of harm to that pet. So the order of protection specifically allows for that remedy. On the bottom of page 19, there is the ability to request child support if the respondent has established legal paternity, and it's a minor child, clearly. The petitioner can request reimbursement for expenses such as damage to property, car tires that have been popped, a cell phone again that's been damaged, and I say that a million times because that happens a lot in our cases. Hospital bills if the petitioner needed to seek medical attention, and other things like that. There is paragraph X, a little I, or a little one, that states if there's a threat to the safety and well-being of petitioner's family or household, if the respondent comes to the resident or stays there while under the influence of alcohol or drugs. This is what we were talking about earlier, and this is really an alternative to asking for exclusive possession. It allows the respondent to come or stay at the home as long as he or she is not under the influence of drugs or alcohol. Clearly don't want to check both. The other thing is that if you read this allegation on its own, it sounds like it probably applies in most cases, right? Most people who are abusive are probably more dangerous while they're under the influence of alcohol or drugs. However, we want to be careful about checking this box because all of the allegations relate to a remedy. So we're making these allegations because later on we're going to ask for this remedy. So you don't want to check this box unless you're asking specifically that the respondent be excluded from the home while only while under the influence of alcohol or drugs. Firearms, as Leslie mentioned, come tell me if you have a case where there's been a threat of firearms or use of firearms against the petitioner, or the petitioner knows the respondent has them. There are additional considerations. The process in dealing with firearms in order protection cases has changed several times just in the past few years. So please come and check in with me. And, school and other records, that is paragraph Y. And you can prohibit the respondent from having access to the minor children's records for a number of reasons. The most common one, and probably the most important one, is if the petitioner's address is remaining confidential, and that's, as Leslie went through a scenario about that and why that would be important. But also, if the respondent is prohibited from having contact with the kids temporarily, we can also ask. And if there's a danger of abuse or concealment of the children. And finally, Z, which is other injunctive relief. As we previously addressed, stay away means no contact by any means. However, sometimes the petitioner does not want to cut off all contact. And a lot of times this actually comes up in a plenary order. In a lot of our orders, we ask for no contact by any means, but at the emergency stage. But then if the parties have children in common, they want some way to communicate in emergencies. They want a way to communicate if there are emergencies involving the children or related to visitation or for holidays or things like that. We can create that exception, and this is a spot where we can create that exception. We can say paragraph 3A except as noted in 17, and this gives us space. It's also where the court kind of has a catch-all. So there are occasionally other things that we put in this section. One is no unlawful contact, which pretty much just prohibits abuse. And sometimes that's all the petitioner wants. They want to have contact with the respondent, but they don't want to have abusive contact. The other thing is that sometimes there are threats to distribute specifically revealing pictures or videos of the petitioner. I say this because this comes up now all the time. If you have a client where there have been specific threats to distribute pictures or emails or some other damaging information to her work or school or family, the court can order that kind of injunctive relief, add an additional prohibition. Although that would be probably considered harassment under the Act, I would absolutely put that under here too. Finally, there are some little checkboxes in here that get kind of lost in the shuffle. One, but they're very important for the emergency order especially. One is at the bottom of page 20, there's double A, and we need to check that box if we're asking that the petitioner's address be omitted. And we need to ask that so that we make the legal argument we need to make, that the petitioner's address needs to be protected. And then on the top of page 21, there are a list of additional allegations for emergency orders only. You're always going to check the little I under there, the top box. because an order of protection isn't an order of protection without paragraph 1, which prohibits abuse. And so at least one of those paragraphs is always going to apply. The other two apply in some circumstances as well. The second one applies when you're asking for exclusive possession of a residence and the court has to balance the hardships. And the third one, little number 3 I's, is where you're asking for exclusive possession of shared property, and the court also needs to balance the hardships. I apologize, I'm a little sniffly today. All right, so as I have promised, the remedies requested section largely follows the allegations section, and it really goes in line, one allegation to one remedy, with a few exceptions. So I just want to address these. The first one is access to the residence, and if you look at paragraph 3C, which is on the bottom of page 21, the court can give the respondent or the petitioner, you can cross off respondent and write petitioner, the ability to go back into a shared residence to get clothing or personal belongings, and to assign someone who needs to be present, which we typically put the police department, the Chicago Police Department or the Suburban Police Department. And that allows the petitioner or respondent to get things they need for the next few weeks while maintaining their safety. Finally, and this will require going on to page 22, to near the bottom where there is the respondent's visitation rights. If the parties have children in common and petitioners been and paternity has been established, you do need to address visitation in some way. There is attached to this packet at the end a visitation checklist for cases involving domestic violence, and also a handout specifically on supervised visitation. It is common practice to check box 7C, which says that the visitation should be denied, cross off denied, and write in reserved, which basically means that right now we're asking for the court to put this aside. Practically, it means there's no visitation for the next 3-week period or until the respondent is served. And then once the respondent comes in and is in front of the court, usually a visitation agreement is worked out between the parties. It may or may not be appropriate to ask for visitation of some sort. That is really a question for your client. And it's also, to a large degree, up to the judge. The judge has to read through these orders, and the judge has to agree to grant an order. So if there are children in common, paternity's been established, so the respondent has some visitation rights, I suggest having a discussion with your client about what he or she wants, what they think is safe, whether they think there's a threat of child snatching, how they think the respondent might react to this order, and then be prepared to make arguments to the judge as to why visitation should be granted in some manner, or why visitation should absolutely not be granted. I just want to explain briefly why in our office we usually ask that it be reserved, and that is because only one party is in court. It's an ex parte order, and so it's difficult to arrange a visitation schedule with the level of protection that we like our clients and their children to have. And when I say protection, that basically means specifics. We want our clients to have visitation orders that allow no wiggle room. So that say visitation is going to occur from 3 to 9 on every other Saturday, exchanges occur at this person's house, this is the emergency contact, and really cover all of the safety considerations that are listed on the visitation checklist at the end of the manual. It's impossible to do that in an order of protection where only one person is present. But ultimately, your client and the judge have to make the final determination as to what's the safest and best for the children. Okay, before we move on to the remedies, before we move on from the remedies to the other paperwork, I just want to ask if anyone who's here has any questions about the petition. Again, I know that's a lot of information, but hopefully the guide is helpful. Yes?
Do you have any thoughts about when you would want to ask for the respondent to have counseling? Because I could see, counseling being good, but also somebody who might not bother contesting something unless it makes them act like go do something.
That's a good question. So the question was when you would consider asking for counseling and how that might play into a respondent contesting a case. If the client wants the respondent to get counseling, I would absolutely ask for it on the petition. The judge can't grant it in the emergency order anyway. When the respondent gets served and you come back to court, I would consider a few things. One of them is whether the respondent is otherwise willing to agree to an order and how important it is to your client. And also, what type of counseling is your client requesting? And then, I'm just going to say finally, whether the parties have children in common. So I personally would probably not go to a hearing just on counseling because the statute is very vague. It allows the court broad powers, but it doesn't really say A, B, and C is a situation where you can order counseling. So I would ask for it. I would see if the respondent would agree to it, and in a lot of cases, respondents do. But I probably wouldn't let it hold up the whole order. Any other questions? And answers to a lot of questions like that are going to be very case by case, and there might be some factors that you want to consider. But ultimately, your client is the person who knows the most about the respondent, and it's really his or her decision. What method, what path these cases take. All right. So I'd like to turn back to the mock case we were going through earlier, and just ask you to take a look at page 27. Page 27 is where the fake case begins, and so we have mock-ups of all this paperwork. The first one on page 27 is the domestic violence cover sheet, and this just lists the names and dates of birth of the parties. And then there are a few check boxes about whether they have children in common or any open cases. Your attorney information goes at the bottom of each page or each document on the left. And on this page, you sign it as the attorney. On the next page is the summons. And you will check the boxes that are checked on this sample. You will obviously have a different petitioner and respondent name. And then on the right side, in the caption, the third and fourth line are very important. They are the address where you will serve the respondent. It may be home, it may be work. It really depends on the respondent's particular situation. Next, on page 29, we have the sheriff's information sheet. And the purpose this serves is to provide additional information for the sheriff who is going out and trying to serve the respondent. So as you can see, it asks for the physical description of the respondent, a number of different types of addresses, additional service information, things like that. It also at the very bottom asks for the petitioner's name and phone number. It says on the PowerPoint to list your contact information. You can list your clients as long as she has not recently changed her phone number. If it's a phone harassment case and she has changed her phone number recently, I would suggest talking with her about what makes more sense. This is just going to the sheriff and it's supposed to remain confidential, but I've got to be honest, I can't guarantee that this won't be sent back with the summons and won't accidentally end up in a court file. So for those really serious harassment cases where your client may have just changed their phone number, I would put care of your name and put that you're the attorney. And then finally, there is we have to skip over the sample affidavit and petition, but if you turn to page 39, there is a sample emergency order of protection. And the first page is different, but the second and third page really do match up with the remedy section of the petition. They look almost identical. On the first page, I just want to draw your attention to about 2/3 of the way down, where there are different lines and lists of names. Please note that the first line is protected persons, the second line is minor children, and the third is animals that are protected by the order. Minor children need to be listed whether or not they're protected parties. The protected party, if minor children are listed, they're not assumed to be protected by this order. There are situations where someone may come in and want an order, but absolutely not want their children on that order. So the reason I'm telling you this is it's not okay to assume that because the kids are listed as minor children, they're protected. You really do need to list everybody who needs protection and is a household member where it says the following persons are protected by this order. All right. So that is the end of the paperwork section. Congratulations, you survived. We are now going to turn to some court procedure and address briefly what you may expect at the domestic violence courthouse and some of the things that may happen in your cases. So the first thing I want to address is conduct. We are in a relatively informal courthouse. However, you're still in court. So there are a few things you want to make sure you do. Number one is turn your cell phones off and tell your client and family and friends to do so. You're going to either give your documents to the clerk on your first court date, your emergency court date, and have a seat, or you may have to get some paperwork from the clerk on return court dates. Respond when your case is called, and this is true especially at court dates. Some of the judges and clerks like to fly through their court calls. So if you hear your client's name, say present, say attorney for James Smith, say the last name of the case, say something, just make sure you stand up and make some noise so that the judge knows that you're coming forward. Introduce yourself and identify yourself as an attorney the first thing whenever you step up to the bench. It's very important that the judge knows that you're an attorney, knows that you're representing the petitioner, that information is on the court record, and that the judge sees that you're asserting yourself and that you are the person to look to, both verbal and verbally, that you're the person to look to answer the judge's questions. That's one criticism that one of the judges in the DV court recently gave. We recently had a recognition event for our participating firms, and one of the judges gave that feedback that the pro bono project attorneys seem a little bit reserved when they step up. You may ask to pass the case if anything unusual happens, and this is true at the emergency stage, but especially at the return court date stage. If you step up and you see the respondent step up, or there's opposing counsel and you didn't know they were there, or the judge starts asking the parties what they want to do and your client says he or she wants to drop this order, which is not what they just told you in the hallway, you can just ask the court to basically pause. So you can ask to pass the case and just step up again in a few minutes so you can sort things out. Additionally, there will be a court reporter either physically in the courtroom you're in or elsewhere in the building. So whether you see somebody typing or not, make sure to spell your name and your client's name, and your client must answer verbally. They can't say uh-huh or nod their head yes or no. They need to say yes, no, and answer out loud. We are going to specifically address what happens at an emergency order of protection hearing. Again, you really want to step up, and before the judge does anything else, introduce yourself and your client. You want to make sure that your client is sworn in before your client testifies, and usually the judges and clerks are really on top of these things, but in the off chance that they're not sworn in, you want to raise that. And the judge may ask some introductory questions and then turn it over to you. The judge may ask all the questions, the judge may look to you to ask all of the questions, and really I think all of those scenarios are fine as long as you do know that you are representing your client and you should feel free to make legal arguments and to interject if it seems appropriate. So for example, I'm going to use the issue of visitation. If your client is very concerned about visitation because there's been a threat to take the children out of the country and the respondent has been physically abusive to her in front of the children and she's very fearful of their main visitation without a firm court order, and you step up in front of the judge reads through the affidavit, asks some questions, those things don't come up. And then the judge starts saying, okay, well, these are his kids, he's your husband, so when is he going to have visits? And your client just starts saying, well, he can see them every other. That is where you need to say, excuse me, Your Honor, we discussed this, my client is very concerned, and advocate for your client. And even if the judge is doing most of the questioning at this stage, please feel free to insert yourself. Most judges, and when I say most, that's an understatement, pretty much every judge will be in front of, at this stage, will allow very, very leading questions because there's no respondent, there's nobody on the other side to object, there's nobody on the other side to cross-examine the respondent or your client. You don't have to go through every incident of abuse at the emergency stage either. I would start with the most recent incidents and then maybe go through one other incident of abuse. And I also finally want to point out that there are model scripts. There's a model script for the emergency order of protection on page 42. And if you look at the abuse history, you will see an example of very leading questions. And the reason why that's there is because the judges really do want you to lead your clients in the interest of time. Also, in the script, there are some advanced issues questions, and those are there to address issues which may or may not be part of your case. For example, children in common, exclusive possession of a shared residence, threats or actual child snatching. So those are things you may or may not need to use depending on the circumstances. Finally, you want to ask about fear of future abuse and notice, and those questions are at the end of the sample script. And ask questions regarding the remedies that require balancing of hardships. So the ones that come up the most often are physical care and possession of children, exclusive possession of a shared residence or other address, or exclusive possession of shared property. And those are the things that either you or the judge really need to go through some of the specifics to show that the balance of the hardships favors your client. So again, those questions are in the script. We're going to address something that has come to be known as petition only at the DD courthouse. So at the end of the emergency order hearing, the judge really has three options. The judge can grant an emergency order, which will last for between 14 and 21 days, and then have the respondent served and have your client come to court for a hearing on the petition for the plenary order. The judge can deny the emergency, say this isn't an emergency, but I'm going to let your petition go ahead, still have the respondent served, and have your client have the opportunity to ask for a plenary order at the next court date. or the judge can deny the EOP altogether and dismiss the case. The third option does not happen that often in our cases. The judges would really need to find that there's not been abuse under the Act. So this is really an inappropriate case to be in the domestic violence courthouse. And typically we're going to be able to screen those cases out far in advance. But there is a chance that the judge may deny your client an emergency order. And this usually happens when the judge does not feel that the case is an emergency. The judge feels that the abuse which has occurred too far in the past, that the petitioner is not in immediate danger, that the abuse which has occurred most recently is not that severe. Now, number one, you can make arguments in front of the judge as to why the case is an emergency. Number two, you can preemptively include information in your affidavit if there has been a delay in the client coming to court after an incident of abuse. Or if there is a situation where, for example, as Leslie mentioned, where the cycle of abuse is taking its course and the abuse is building again, and your client is fearful of something that has happened, which might seem minor if you don't know the history and the fact that this has been a precursor to abuse in the past. So you can put that information in the affidavit, and you can make those arguments. But if, at the end of the day, the judge does not grant the emergency order, your client really has two options. And one is to proceed with the case, which means that he or she may be able to get a plenary order, but the respondent will be served and she won't have an emergency order to protect her in the meantime, which she may feel puts her in more danger than she is right now. If that is the case, you can withdraw the petition, which pretty much makes it as like this case never happened. The respondent never gets served and the case does not go forward. If this is a situation that seems like an emergency order may not be granted, I'm going to prompt you to have that discussion with the client in advance. But just know that if you step up and this happens, this is a situation where you can always ask to pass the case and just tell the judge you need to consult with your client to see if he or she wants to proceed with the petition, and go in the back, there are rooms in the back, and talk to your client and see what they wanted to. Okay. We have alluded to this, but to address it directly, the respondent will be served by the sheriff and given a copy of everything that you prepare for court, the affidavit, the petition, the summons, really all of the court paperwork with the exception of the sheriff's information sheet and the cover sheet, which the cover sheet will be in the court file. The respondent will get a copy of any orders that are entered. So if there's an order entered, an emergency order, or if there's an order entered saying that the emergency is denied, but the petition is going to continue, the respondent will be served with that. In Cook County, this happens automatically in these cases. So you don't have to take any other steps. The clerk in the courtroom will put the package of information together and send it to the sheriff's office. You will have to call the sheriff's office or check their website before your return court date to confirm service. And know that proof of service should be sent to the clerk's office so that it's in the court file by the time you come back to court. If you have any issues with those things, let me know and we can sort of troubleshoot. Also on page 49, there's a very detailed explanation of different types of service of process and what you may need to do if your the respondent lives or works out of Cook County, or if you have persistent issues with service of process, what other steps you may need to take. I mentioned your return court date. You will come back after the emergency hearing for at least one additional court date. Some cases are resolved at that date, some are continued a few times. Overall, though this should be a relatively short pro bono commitment, your case should last between a few weeks and a few months at most. There are 4 things that may occur, or 5 things actually. One is that you can proceed to hearing on the plenary order of protection. That is unlikely to happen on your first return court date. And you can ask for a continuance so that you have the ability to prepare for hearing, call witnesses, and get evidence together. And so please know you don't have to go to hearing right then and there. If the respondent has been served and is not there, you can go to what we call a default prove-up, basically to ask that an order be entered by default. You can enter an order of protection by agreement, and this happens far more often than one would probably think. You can continue the case and extend the emergency order for any number of reasons. I mentioned that you may want time to prepare for hearing. The respondent may want to hire an attorney or bring in witnesses of his or her own. The court may not be able to accommodate you, or there may be issues with service of process. So those are all reasons why the case can be continued. Finally, you might want to ask that the emergency order be terminated and the case be dismissed, either because your client is present and does not want to proceed, or because your client has decided that he or she does not want to proceed. Order of protection. I know that Leslie mentioned this, but because this has come up, we do yearly surveys with the Pro Bono Project, and because this has come up on a few occasions, I just want to stress that in many cases, clients come in to get an emergency order and do not proceed to a plenary hearing or a plenary order of protection. And there are a number of reasons why that may be the case. One is that domestic violence is a cycle, and leaving an abusive relationship is a process. On average, victims make 7 or 8 attempts to get help in some capacity before they finally leave an abusive relationship. The other thing, though, is that for a lot of petitioners, the emergency order of protection may be enough. It may have been what they needed to keep them safe while they moved, while they changed their phone number, while they got a new schedule at work, and took whatever practical other safety planning steps they needed to separate themselves from the abuser and get themselves to a safer space. The fact that your client does not come to the court date and does not want to proceed does not reflect in any way on the quality of your representation, and it absolutely does not mean that the client is not grateful for your help. It's just, I cannot stress that enough, because I don't want you to be discouraged as volunteers if you have a client who does not come back. That being said, attorneys represented by Pro Bono Project, clients represented by Pro Bono Project attorneys are nearly twice as likely to return and obtain a plenary order than they would be if they did not have an attorney. So you are absolutely having a big impact in that way. So there's just a few more things I'd like to address. One is continuances. I mentioned reasons why the case could potentially be continued. There is a one-page sheet called a disposition order that extends orders while cases are pending. So your client's emergency order, if one is granted, should remain in effect. There is an explanation in the manual on page 52 of the various things that can happen on a return court date. Terminating an order of protection, we discussed that clients may not appear to court, may not return for a variety of reasons. You still need to come to court and explain to the judge that your client does not wish to proceed, and ask that the order be terminated and the case be dismissed. And just know that there's always going to be an order entered. So you should always wait, even if the order is just saying that the case is dismissed. The judge may or may not give you an option as to whether an emergency order is terminated or vacated. I just want to throw a note in here that terminating means that the order ceases to exist from this point forward. Vacating means legally it never existed. This has ramifications for LEADS, which I mentioned before is the law enforcement system and how it is processed, and potentially your client's ability to reinstate the case if they choose to reinstate it within 30 days. Legally, if the client terminates the order and then changes his or her mind a week later when the abuse picks up again, they can come in and file a motion to vacate and reinstate. If the order has been vacated, legally there really is no order to reinstate. It's like the order was never entered to begin with. So we're really trying to make sure that everybody, judges and advocates and court staff, is clear about that distinction. Disposition orders, there's a sample on page 54. As I mentioned, they can extend orders and continue cases. They also are where you would terminate an order and dismiss a case. You can ask for a copy when you get to court on your return court date. You could just go up to the clerk, and even if the clerk is not checking people in as a way to manage the court call, they should be able to give you a partially filled out disposition order that you can make sure has the correct information. It's just important to note that if you're continuing the case, you need to do two things. There's box number 1 and box number 2. One extends the order. The second one continues the case to a future court date. Those are both things that are important in these cases. If the respondent appears and is willing to agree to an order, you should draft a plenary order, and plenary orders are available online on the Cook County Clerk's Forms website and also at the courthouse. Both parties should review and sign it, and then you should step up, explain that the parties have an order, and go through the terms of the order so that they're on the record and it's clear that the respondent knows what he or she is agreeing to. As I previously mentioned, there's the potential to get a default order if the respondent has been served and has not come to court. There are default questions on page 59 that are very short. There are probably 7 or 8 questions. And really, it's what's important to the court is that the petitioner's testimony in the form of their petition and affidavit was true and correct on the first court date, and that it's still true and correct, that they still need the order. Most judges do not make you go back through and testify again about the incidents of abuse, because there was a basis on which to grant an emergency order to begin with, usually. Finally, I would just like to address very briefly that some of your cases do go to a contested hearing, and this may or may not involve opposing counsel. So there are certain things that you want to do before your actual hearing date. And again, usually a hearing is on a planned date, not just the first return court date. You want to have the client review their affidavit. And it's important that they remember what happened and specifically when. You want to explain to your client what will happen in court and do what you can to make him or her more comfortable. So prepare the client to pause if there's an objection, to take their time, to only answer the questions that they're asked, and to always be truthful. Prepare your client for the way each incident will be presented, the fact that you have to go through foundational questions, then the incident, and then you might ask for some background information, but you can't just start with 5 years ago this happened and tell the story in the way that most people would tell a story. You also want to prepare your client to control their emotions. Let them know that the judge watches as well as listens. And so sighing, shaking your head, and yelling that somebody lies, or muttering under your breath, which are all things that are sort of natural reactions to somebody lying about your testimony in court, are things that they need to fight as best they can. And I would practice some questioning and possibly some cross-examining questions. And then finally, asking what the respondent will likely say can help you plan your cross-exam and your closing argument. And that's something that only the client will know. Finally, discuss any possible witnesses or evidence and review the rules for introduction of evidence. If you have any witnesses, make sure you speak with them personally. Make sure you know what they can and will testify to. It may be harmful to your client. They may know nothing. Your client may just have told them what has happened. So you need to speak with them yourself. And at the start of a hearing, you can make an oral motion to exclude witnesses. Now, most of the judges do this. Most of the judges call whoever's there at the beginning of the hearing up, ask who has witnesses, and put them out of the courtroom. But and this is actually in the script for the plenary order. That is part of your handout because it's so important. You do not want somebody who has sat there and heard your client's whole testimony to then be called to testify as a witness. Their testimony will be tainted. On direct exam, you do now have to ask non-leading questions. It is important to go through all the incidents of abuse. And don't forget that you are asking for specific remedies and that some include balancing tests. The fact that you've covered that at the emergency stage is great, but you need to go through those things again. On cross-exam, you can use this opportunity to point out inconsistencies in the respondent's statements, and also just be aware of incidents that the respondent does not dispute. If the respondent only talks about one and what really happened in one of the 5 incidents that your client has testified to, you can bring that up on closing. They have not disputed the incidents of abuse. And this is a civil case. The standard is preponderance of the evidence. It's slightly more likely than not that an incident of abuse has occurred. That's all the court needs to find. Finally, I would prepare to do a short closing argument, a paragraph or 2. Remember that time is of the essence. You're working in crowded courtrooms, but it gives you the opportunity to sum up your case and make legal arguments. Again to remind the court of the specific remedies that you're requesting and why. It's good to review the statute. You all have copies of the Illinois Domestic Violence Act. It's a very short statute. Point out errors in the respondent's case. If he did not talk about specific incidents at all. And also, keep in mind that if he admits any abuse, the Illinois Domestic Violence Act states that an OP shall issue. And then there are 2 things. That in a plenary order, and there is a sample in the packet, it's very similar to an emergency order, except that expiration information is contained on the first and last pages, so it's important that those 2 pages, both areas are filled out and that they match. Additional relief can be granted in a plenary order of protection, including visitation. And because of that, we've included some resources about visitation. It's important, the most important things are to make the terms clear so there's not a lot of wiggle room. Also can allow some contact in emergencies, and this could be through a third party, this can be through email or text so that there's some record, but we want to be cognizant of the fact that if there are kids, somebody's going to get sick, someone's car is going to break down, somebody's going to need to work unexpectedly, and we really want these orders to work. And finally, do not contradict other provisions. So, for example, 3A, stay away means no contact by any means. So it's important to put an exception if you are going to allow a visitation contact. So that is the end of our presentation. I wanted to call Leslie up because she's going to go through some sort of logistics, but also to see if anyone has any more questions before we stop the video. Anyone? Oh, thank you for your time.